The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. Good afternoon. This is the time set for oral argument in Charles and Joan Clancy versus Desert Schools Federal Credit Union, our case number CACV 160018. Each side is allocated 20 minutes for your oral presentation. Appellant may reserve a portion of that time if you wish to do so for rebuttal. If you wish to do so, you'll need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask that those in attendance make sure your telephones are off so our discussion with counsel is not interrupted. We have reviewed the briefs. We've looked at the record. We've conferenced the case. We're familiar with your case, and we'd appreciate it or encourage you to keep that in mind as you present oral argument to us today. Proceedings are being recorded and will be posted both to the court's website and then to YouTube in due course, so please, as you approach the podium, announce your name and the party that you represent for those purposes. With that, Mr. Miller, you may proceed.
Thank you, Your Honor, and we appreciate the time we have for oral argument. My name is William Miller, and I represent the Clancys. I would like to emphasize three key facts that I think form an umbrella over our argument. And then I will quickly go over the four issues: collateral estoppel, statute of limitations, and the attorney's fees issue, and the compulsory counterclaim issue. One of the things we're dealing with is Judge Herod's ruling. And I firmly believe that if you read that, and it's long, if you read the portions that talk about the efforts of Desert Schools, the only defendant in the underlying case, he limits their good faith to a time period from March of 2010 to January of 2011. He doesn't say whether or not they acted in good faith before that nor after that. The allegations in the 2014 complaint that Judge Blomo dismissed on summary judgment, some of those call into question in August of 2012, such as the setting up of this separate purpose entity called a CUSO, who repossessed the property. And some of those actions go into activities in the summer of 2011. So when we talk about claim preclusion, I think the Phoenix newspaper's case gives us the broad ability to bring these claims. Issue preclusion is interesting because while they did win on the covenant of good faith and fair dealing for that window of time, well, we also won. And we also won that there was a breach of the covenant of good faith and fair dealing. So if you take those two issues, it's a little bit of a push. I think the 2014 claim takes us out of that area.
Counsel, but isn't this really all of one piece, regardless of whether any discrete action occurred at any particular time?
This is an absolutely fantastic question, and believe me, we laid up hours preparing that complaint and then these appeal briefs. I think that in a traditional sense, your intuition is 100% right. Wait a minute, you can't come in here and challenge this foreclosure and these purported loan mods. You had all that time. But when you look at the allegations we've made against the CUSO, and you look in the summary judgment what our experts said about the CUSO, and when you look in the summary judgment what Mr. Chamberlain, a former officer at Desert School, said about the CUSO, then you have to ask the question, is that entity an entity that should be disgorged of the benefits it got from this foreclosure?
Well, but aren't you making the same claim? You're just relying on different facts to support the same claim?
I think we are,
Then if it's true, doesn't that kill your argument then?
Well, I think if we have, under the Phoenix newspapers test, if we have new facts in the 2014 complaint, then I think we're not precluded from bringing those claims. I believe that the quote that might be apropos under that case, and I know that it is the minority rule, 100%, and I know that it's still good law in this state. And I'll read that for Your Honor because I think it's very helpful. Now, these are direct quotes from Phoenix newspapers, and it talks about the same evidence test. This all relates to the collateral estoppel argument. For an action to be barred, it must be based on the same cause of action asserted in the prior proceeding. Arizona has applied a rather restrictive test to resolve this question. If no additional evidence is needed to prevail in the second action than needed in the first, then the second action is barred. They go on to say that under this same evidence test, for example, and this is where my heart stopped because I didn't know this, an action on an open or stated account is not barred by a prior action on a promissory note, even though both actions are based on the same debt. And that's the Wilson versus Bramlett case. Now, I believe that's the law here as it relates to collateral estoppel. And I believe that when we brought these new claims, the same evidence test would not bar us from bringing those. The third and final fact that I want to bring home before I go over the other four real quickly, the four issues real quickly, is that in the underlying case, there were two counterclaims that the Clancys had brought. They had been sued by Desert Schools for foreclosure on properties, 4 pieces of property. 2 ended up being tried. 2 were settled. There was a promissory estoppel claim where the Clancys had said to Judge Herod in a bench trial, hey, they promised me a loan modification and they didn't give it to me. He threw that out on summary judgment. The one claim that survived, so the only claim that we're weighing against these new claims we've brought, fraud and negligent misrepresentation, aiding and abetting and conspiracy, the claim that was tried before Judge Herod was the breach of covenant, good faith, and fair dealing one. And that was it. So with that said, I think that we survive on the issue of collateral estoppel. Now, quickly on the compulsory counterclaim issue, I read and we read Rule 13 to say that at the time the pleading is filed, at the time the answer was filed by the Clancys, did they have a ripe claim? And all they had was those two. The promissory estoppel, they lost on, and then the breach of the covenant, good faith, and fair dealing. They did not know, nor had they alleged at that time, that the bank was engaging in suspicious and nefarious conduct. And the CUSO, the separate purpose entity that we're so aggressively attacking, wasn't even formed until August of 2012. So we didn't even know about it at the time. And there's a couple of things that are important to note. It's in the summary judgment papers. 2 reasons we're attacking this CUSO is because, 1, the individual officers and directors of the bank were the members and owner of that CUSO. And our expert has suggested, David Schweikert, that could possibly be for off-balance sheet purposes. And 2, we found a letter in the 2014 case from a records search at the Arizona Department of Real Estate that Mr. Hunton, one of the defendants we sued in this lawsuit, not named in the previous lawsuit, no individuals were named in the previous lawsuit, he has had deals with his father for years and years where he takes the REOs from these financial institutions and gives his father's favored deals on those. So those type of things we could never have brought up at the time that the original answer and pleading was filed. Two more issues, and then I'll try to save a few moments for a little rebuttal if it's necessary. As to the statute of limitations.
Let me ask you,
Sure.
and perhaps that's where you're headed, but you say you could not have brought those. Is that because you lacked actual knowledge? Is that because you lacked constructive knowledge? Is that what causes you to say that?
Terrific question. The tortious conduct didn't occur at the time the 2011 lawsuit was filed, was October of 2011. The real tortious conduct didn't occur until 2012. That's when this CUSO was set up, and we begin to be having some significant problems with the bank. So when you talk about the activity that we're suggesting in this case is inappropriate, in the 2014 case, it didn't exist at the time. So I would say we didn't have actual knowledge. Unfortunately, in a deposition, Ms. Clancy did say I had suspicions that some stuff was going on, but I'm quite sure, Your Honor, that the law requires knowledge of facts, not suspicions. So
Well, let me ask you, and perhaps again that's where you're headed with a limitations claim, but isn't accrual kind of, doesn't that turn on know or had reason to know of certain things?
I think it does. I think it does.
Why wouldn't that have traction for the compulsory counterclaim question?
Well, they couldn't have sued for fraud at that time because there were just no facts that we had any knowledge of when that was filed. We didn't have any of the banking records. We didn't get these loan committee records until subsequent to 2013, July of 2013. So we couldn't have done much more than we did.
And so suspicion is, your position is irrelevant for a compulsory counterclaim?
I think so, Your Honor. I think the Coronado Development versus Superior Court case says that it has to be knowledge of specific facts, not uneasy feelings and such. And I wrestle with this a lot with clients. They say, these guys did this or that, and we always do the same thing. We need a little bit of meat on the bones before we can just file these type of shotgun claims. So I just don't think they existed back in October of 2011. I just don't think they did.
Well, what was the act of fraud or the improper conduct upon which you based your new claim?
Well, the improper conduct we claim occurred on or about August of 2012, when the banking officers at Desert School set up this CUSO to repossess this asset and own it in their individual names.
And that's improper?
As far as we can tell, under the Code of Federal Regulations and under our experts' analysis, a CUSO is set up to do the following. It's called a credit union service organization. It is to provide benefits to the members of the credit union, such as offering discounts for insurance, helping its members with payroll, helping them prepare their taxes, and maybe giving them financial advice. But to our knowledge, and this was put before Judge Blomo, not once were we aware of a CUSO owning real estate, because it seems inconsistent with the reasons that the Code of Federal Regulations allows this. So we feel that was just improper on its face, and it just is common sense that the officers and directors of a bank can't hold an interest in a real estate asset. So quickly address attorney's fees, and then I'll try to save a few moments. The two thoughts for Judge Blomo's award of attorney's fees would either come out of 12-34101 or out of 12-349. The Ramsey Air case really seems to be favorable to not awarding attorney's fees under a 12-341 analysis. That says that the existence of a contract that merely puts the parties within tortious striking distance of each other does not convert the ensuing torts into contract claims. So in other words, the fact that they knew each other and they had some business together doesn't necessarily shift that gear into a 12-341 analysis. A tort claim will arise out of a contract only when the tort could not exist but for the breach or avoidance of the contract. When the duty breached is one implied by law and based on the relationship of the parties, the claim sounds in tort and not contract. So we don't think a 12-341 analysis is proper. As to 12-349, I think we've got 3 or 4 pretty significant factors. Most important being His Honor did not dismiss the case on a motion to dismiss. And the summary judgment, in all due respect, these are terrific lawyers, but it's just a rehash of that. It's just basically the same thing. So he didn't dismiss that. That gave us the green light to start doing our discovery and getting the ball rolling. And, we had felt that after looking at this Phoenix newspaper's case, we clearly had a strong basis, a good faith basis to bring this claim in 2014. And then finally, Judge Blomo never did undertake any findings of fact or conclusions of law saying, hey, you guys messed up. You didn't shepherdize Phoenix newspapers or whatever. So I don't think that's an appropriate analysis. I'll close with this. The motion to compel, which was denied, was fully briefed and at issue with a response and a reply and a certificate of counsel and everything, with the documents our expert needed to really put his conclusions forth. That was fully briefed before Judge Blomo 1 month before he dismissed us on the MSJ. He also had before him the Rule 56F motion. That's not part of this appeal. We agree, but it's a subtenet of both dismissing a claim before we've had a chance to do our discovery and dismissing it when we're being very specific as what other information we need. So if there are no more questions, I'll save my 4 minutes. Thank you very much. I appreciate it.
Thank you. Mr. Davis.
Thank you, Your Honors, and may it please the Court. My name is Gregory Davis. I'm joined by my colleague, Gregory Satrum, and we represent the defendant appellees in this case. It was after a 5-day trial that Judge Herod concluded that Desert Schools at all relevant times had considered the Clancy's loan modification in good faith. And by doing that, he rejected the Clancy's argument that they had made throughout that trial that Mark Hunton had lied to them regarding the status of their loan modification. Before judgment was even entered in the original litigation, the Clancy's filed this duplicative lawsuit. The allegation that Hunton misrepresented the true status of their loan modification request is the same in both lawsuits. Those aren't my words. That's a direct quote taken out of the controverting statement of facts of the Clancy's in this case. That can be found at Appendix 272. The Clancy's argue that they're afforded a second bite at the apple here because they have recast their bad faith claim as a fraud claim, and they have added as defendants some of the employees of Desert Schools that were involved in the loan modification discussions that were at issue in the original litigation. But the Clancy's are bound by the ruling in the original litigation, as Judge Blomo correctly held. Judge Herod's ruling that Desert Schools at all relevant times considered the Clancy's loan modification in bad faith collaterally stops them from asserting the fraud claims that they are asserting here. And that's because in Arizona, a party can't act in good faith if it falsifies facts or withholds material information or otherwise engages in dishonest conduct. It's simply impossible in the state of Arizona to, on the one hand, consider loan modification in good faith, which is exactly what Judge Herod concluded occurred here, and on the other hand, commit fraud with respect to those very same loan modifications, which are what the Clancy's are alleging. And in addition to being just a try-again lawsuit that's barred by collateral estoppel, the Clancy's claims are each barred by their independent statutes of limitation. Depending on which claim we're discussing, There are 1, 2, and 3-year statute of limitations at issue here. The Clancy's complaint in this matter was filed on August 18th, 2014, which means that using even that most generous 3-year statute of limitations, any causes of action that accrued prior to August 18th, 2011 are time barred. The Clancy's have argued in their papers that their cause of action, in fact, accrued in 2013. Judge Blomo considered that, and he said that contention, quote, is not consistent with the facts or the record. And he held that the Clancy's claims were time barred and granted summary judgment on that ground. To affirm summary judgment, however, your honors don't even have to evaluate the tolling argument that the Clancy's have raised. And that's because to benefit from the discovery rule here, because the Clancy's complaint demonstrates on its face that it is barred by the statute of limitations, which is to say, and Judge Howe, I think this answers your question, all of the allegations that form the basis of the claims the Clancy's have asserted here are communications between Mr. Hunton and the Clancy's that occurred in 2010, outside of the limitations period. So it's plaintiffs in that circumstance that have to come forward with evidence demonstrating that through the exercise of reasonable diligence, they wouldn't have known of their fraud claims, and they haven't done so.
Let me ask you about to what's your response to the CUSO being stood up in August of 2012?
A couple, Your Honor. Firstly, there are no allegations in the complaint that attempt to tie arguments regarding the structure of Desert Schools and its credit union service organization to the harm that the Clancy's are alleging to have occurred. They've alleged fraud claims and misrepresentation claims and concealment claims, and all of those damages they've argued, and of course there's no evidence for this, but they've argued that the damage was the result of them not getting alternative financing. There's been no link to.
That's a little different, though, than whether a claim is barred by the limitations period, right?
Well, I guess I would suggest that they don't even have a claim. There is no such claim.
That's a 12b-6. That's when I don't know that it's been briefed that way throughout the history of this case.
Certainly, Your Honor, and of course there's been, and this goes to an additional issue that Judge Blomo ruled on, or excuse me, that he didn't rule on, but could have, and of course which Your Honors can affirm on, is the complete lack of evidence here. At argument, there was some reference to federal rules. Quite frankly, I don't know what rules he's speaking about because they were not found in the briefs. They haven't been argued below, and there was no evidence presented to Judge Blomo regarding any injury that the Clancy's purportedly suffered as a result of the structure of the credit union, which they would have needed to present. With respect to the last point on statute of limitations, the Coronado case, I must admit I think that's one of our strongest cases because it very plainly states that when a plaintiff has suspicions that the defendant is engaging in nefarious conduct, those suspicions bar the tolling of the statute of limitations. The court specifically said, quote, "It appears the respondents were suspicious of the petitioners, but still did nothing to either investigate further or commence their lawsuit. Under these circumstances, the statute is not tolled." And Ms. Clancy plainly has these suspicions. When she was deposed in the original litigation, she stated that with respect to Mr. Hunton, by late 2010, she, quote, "had an uneasy feeling that maybe he was lying to me, maybe he was lying to me all along." And under those circumstances, tolling simply is not applicable, and certainly plaintiffs haven't come forward with the evidence, as they must in this circumstance, to demonstrate that the statute of limitations does not bar their claims. Moving to Rule 13, which is the third ground on which Judge Blomo granted summary judgment, as Your Honors well know, with certain exceptions that aren't really applicable here, Rule 13 requires that the defendants assert as a counterclaim any causes of action they have against the opposing party that arise out of the same transaction or occurrence as the main claim. If those counterclaims are not alleged, then they're forever lost. And
what happens if evidence to support the claim is later developed?
Judge Howe, certainly a claim must be mature to be a compulsory counterclaim, and they are mature here. And you've touched on the only argument that the Clancys have asserted regarding why Rule 13 doesn't bar their claims is because they say they just hadn't accrued at the time they filed the counterclaim. Well, frankly, that's just not true. The counterclaim was asserted here on November 20th, 2012. And all of the facts that the Clancys needed and all of the facts that gave rise to accrual of their claim occurred in 2010. There are various emails from Mr. Hunton to Ms. Clancy in the record throughout 2010. I would direct you to Appendix 227, 121, 124, and 133. Those are the four that I think are particularly helpful. But those are emails from June, July, November, and December of 2010 in which Mark Hunton is freely disclosing that the loan modification proposal hasn't been submitted yet. Of course, that is diametrically opposed to the assertion that the Clancys have made that they never learned that the loan modification proposal hadn't been submitted until 2013. And of course, they're the suspicions we discussed. But the causes of action accrued in 2010, and thus, as a result of them not being pled in the 2012 counterclaim, they were barred. And Judge Blomo was correct to grant summary judgment on those grounds.
And your position is that the magic time to determine what a compulsory counterclaim should have included is November 20, 2012?
Yes, Your Honor. And we touched on it briefly before, but I'd like to address it again because I think it's important that in addition to the three grounds that Judge Blomo relied on for granting summary judgment, he very well could have granted summary judgment on each of these claims because of the lack of evidence here. And on this point, Your Honor, I don't think there's very reasonable dispute because during oral argument on Desert School's motion for summary judgment, opposing counsel conceded we can't prove up our claims at this time. And he was right because there was no evidence in the record that the Clancys justifiably and detrimentally relied on the alleged representations of Mr. Hunton, which is fatal to their claims for fraud, negligent misrepresentation, and consumer fraud. There was also no evidence of a statement of present fact, which is necessary for a negligent misrepresentation claim. Under no circumstances can a claim for negligent misrepresentation be based on statements about the future. And then the concealment claim, there was no evidence of a misrepresentation. And there was additionally no evidence that Mr. Hunton intentionally prevented the Clancys from learning about the status of their loan modification. In fact, all of the evidence in the record demonstrates that he was disclosing that throughout 2010. And so those are additional reasons that Judge Blomo's grant of summary judgment should be affirmed. And I'll leave you with this, unless there are any further questions. With respect to Phoenix newspapers, Judge Blomo's grant of summary judgment was not based on res judicata. It was not based on claim preclusion. It was based, as we've discussed, on collateral estoppel, statute of limitations, and Rule 13. Our papers are quite clear that we disagree that Phoenix newspapers is still the test for res judicata, but res judicata is really a one-way ratchet here. If Arizona, as has been demonstrated in the Tukakamori case and Hall v. Lawley, has adopted the more modern transaction or occurrence test, then res judicata is now just a fifth ground for affirming summary judgment. If we haven't, if Arizona still follows the Phoenix newspaper case, then summary judgment should still be affirmed for the three reasons that Judge Blomo identified in the additional one that we've discussed today. And I ask that summary judgment be affirmed, Your Honors. Thank you.
Thank you, Counsel. Mr. Miller, rebuttal.
I do not have anything to add. Thank you very much.
Very well. Thank you. Counsel, we appreciate your arguments. We appreciate your briefs. You've given us much to think about. We will take this matter under advisement. We'll issue a written ruling in due course. Thank you. Court will stand in recess while we set up for a next oral argument. We will remain on the bench while that occurs. So thank you.